I'm going to discuss two rules that are going into effect in 2022. And they actually are not in effect yet. They will be effective March 17th of 2022, so in a couple weeks. So you're getting an exciting free preview of what's to come. The first one of these rules has to do with broker supervision. So under our current law, there's very little guidance for brokers on what it means to supervise. Basically, the law says brokers must be in a position to supervise, and it doesn't really go much further than that. So this rule puts forth, and this is not an exhaustive list. There's going to be other things that happen that can fall under broker supervision. But I think of this as kind of a roadmap or to-do list, a to-don't-do list for you guys, for the qualifying brokers. And so you know kind of what the commissioners expect regarding the word supervision. There's 13 of these. I'm not going to go through all of them. I'm sure you're going to read them as soon as they're released. But I do want to highlight a couple of them and then just give some real life examples of this. So the first one I want to talk about seems very, very basic, but it's very important. And that is the fact that one of the things obviously expected of qualifying brokers is that your license is in good standing, that it's not inactive, it's not lapsed, that you've kept up with your CE, that you've paid your renewal fees. Because if your license lapsed, all those licenses of your salespeople underneath you also lapse. So you're the foundation. And so we just want to make certain that that responsibility is to keep your license as it should be. The next one I'm going to talk about is just simply allowing someone that works for you that does not have a license to do licensed activity. So a good example of this is if you were set to go to an open house and then one of your children got sick and you had to send, you were in a bind, so you sent one of your clerical staff to the open house alone. Well, that is licensed activity, and so that would, be something that would be considered definitely a violation. So there's some guidance on that issue. Another one is allowing people who have worked for you in the past, or maybe work for you in a different capacity now, to do activities that require a license, but their license may be on inactive status or expired. You just need to make certain you know the status of their license. So let's say that their license is currently inactive, and they send a client to you, and the client decides to list with you, or you help them buy a home, and there's a commission paid, and then you give a little referral fee over to the person that helped send the client to you. Well, they're on inactive status, so they're not allowed to have that. So that's just something else on the list that we would expect a qualifying broker not to do. The next one I'm going to talk about, I think, is the most important thing on the list. And the reason I say that is how you react to this particular one is going to determine how we as legal decide whether or not to place a qualifying broker also in a formal complaint. And that's going to be number 8 on the list. And it's failing to timely take action to correct or mitigate a violation of license law or regulation after you learn of the violation. So I'm going to give you 2 examples and how they went 2 different ways. We had a licensee, his license had lapsed, and just because of some mitigative circumstances, he did not realize that. And this was for about a 2-month period. And he continued to transact business, he continued to enter into listings, go to closings, and receive his commission. Well, the day he realized that his license had actually been lapsed for a couple months, he immediately called his qualifying broker. His qualifying broker immediately called me, and they actually got the qualifying brokers of the parent company involved as well. They were very upset about this. They wanted to know what they needed to do immediately to try to remedy it. The salesperson actually paid back the commission that had been paid during this time. So because of that, now we did file a formal complaint against the salesperson, but I did not include the brokerage in the formal complaint because as soon as they learned of this, they contacted us and let us know. The opposite of that is a situation that occurred where the qualifying broker learned that one of her salespeople was doing property management on the side. And we know she knew this because of some emails that we found. And she admonished her about it, but then never followed up about it, and the woman continued to do it, and she did not contact us about it. In that circumstance, we did include the qualifying broker in the formal complaint. So it's just so important. Your reaction is going to determine basically my action in moving forward. Another one is failing to oversee or account or properly handling money. Obviously, everyone knows this. As the broker, you're responsible for all the trust accounts. But this actually goes and extends a little bit further than that. One of the #1 complaints we have from consumers is regarding earnest money. So this is just, you need to remember that if you have a salesperson who has entered into a contract and earnest money is part of that contract, that it's supposed to be received and delivered, and this may be delivered to a third party, a title company or a closing attorney, so not necessarily delivered to your brokerage. You just need to make sure that that actually happens, because these transactions fall apart, and that's when people realize the earnest money was never collected. So it's just making sure that, that your salespeople understand and know that they have that responsibility, even though it's not going to the brokerage, to get it to the title company or to get it to the closing attorney. Okay, this is one of the ones that's probably my biggest pet peeve. And this is failing to ensure that the company's advertisements or its licensees' advertisements comply with license law. So the #1 complaint we get with a licensee calling about another licensee is about social media advertising. So then I spend about 2 hours looking through someone who I don't know, their Facebook post. And if you know that you have salespeople, and this is asking a lot, I understand that are actively advertising on social media, you need to every now and then glance at that social media and make sure that they are in compliance with the license law regarding advertising. So again, this law is not exhaustive. This rule is not exhaustive. It's just a list of things to help guide you and a list of activities that you can definitively say, if you had to go in front of the commissioners, they would consider this lack of supervision. Any questions about that one? All right, the final one I'm going to discuss has to do with applicants who have a criminal history. And this, as you all know, whenever you want to become a licensee in Alabama, you must get fingerprinted. And then that fingerprint leads to a criminal history check. It's a national check run through NCIC. So it's going to check all local, state, and all federal crimes. And then we get, as the legal division, we get that report back. If you've committed any felony, you automatically have to go in front of the commission for them to approve you to move forward. If you've committed a misdemeanor, it depends on the type of misdemeanor you committed. So let me give you an example. We call it, it has to be a misdemeanor of moral turpitude, a crime of moral turpitude. So basically, if you got a first offense DUI, you do not go in front of the commission because that's not a crime of moral turpitude. A crime of moral turpitude normally involves fraud as an element. So if you wrote a worthless check, then you would have to go in front of the commission because fraud is part of the crime of writing the worthless check or negotiating a worthless instrument. So you would have to go in front of them. One of the things that the commissioners have to consider whenever people appear in front of them with these criminal histories is they have to determine if an applicant is qualified and fit to hold a real estate license. So 2 of the criteria they really look at in making that determination: has the person paid back their fines and fees that are owed to the court system or their restitution that's owed to the victim? They also look to see if that person is still on probation or parole. Normally, when they see that a person still owes money or still is on probation or parole, they feel like they haven't really reached that point yet where they should be able to hold a real estate license. So this rule now allows that when we have someone that owes money or is on probation or parole, that applicant can be rejected at staff level. And the reason this is important is that we have so many people applying that do have criminal history. And most of the time, quite frankly, the criminal history is a bad check that was written 18 years ago. But we want to get the people in front of the commission that we feel are going to be approved as quickly as possible so they can move forward with their licensing. Please know, though, that if we reject someone at staff level, that they receive a letter and they still can ask for a hearing within 30 days. So they still have the right to come in front of the commissioners if they don't like that we rejected them. This just allows us to send that letter at the beginning. Another thing that this rule allows, it allows us to reject an application at staff level for anyone that lied on their application. So there's a portion, as you all know, that asks if you've been arrested, imprisoned, fined, probation, parole. You know, people a lot of times, they just put no, 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 no. We're going to find out that there is a criminal history, and the defense of, I forgot, I wouldn't forget a night in jail, I'm sure most of us would not, doesn't fly. So if they lie on that application, then again, we can reject them at staff level, but Again, they have 30 days to request a hearing, and they can come back in front of the commissioners. So we're just hoping that this kind of streamlines this process and allows more room on our agendas for people that have paid off all the money they owe, have gotten off probation and parole, to help them move forward in a quicker way.